वेलकम बैक टू आवर चैनल एवरीवन। आज हम खत्म करेंगे लिमिटेशन एक्ट फॉर द अपकमिंग हरियाणा जुडिशरी 2024 टू बी हेल्ड ऑन 3rd March. This is our second video of the Haryana series. We have already finished the partnership act with all state previous year questions. You can click on the I button to watch that video. In this video we will be going through short notes and all state previous year questions of the limitation act. हम starting में disclaimer देना चाहेंगे, अगर आपको limitation act बिल्कुल भी नहीं आता है then stop this video right here because we are not going to teach you the limitation act. This is a revision video. लेकिन अगर आपको बिल्कुल भी limitation act नहीं आता है then don't worry. If you watch this whole video, we guarantee that हरियाणा जुडिशरी में जो 3 से 4 questions आएंगे limitation act के, वो इस वीडियो में कवर हो जाएंगे। और अगर आपको आता है limitation act, then watch this video as a supplement just to check whether you have covered all the points or not. So without wasting any time, let's begin. So first thing that you need to take care of is that preamble tells us that this act was made to consolidate and amend the law relating to limitation in India. It is applicable throughout the whole of India. It received assent of President on 5th October 1963. The enforcement date is 1st January 1964. There are 5 parts, 32 sections and 1 schedule, and in that schedule you will get 137 articles. If we look at the scheme of the act, part 1 talks about preliminary things and stretches from section 1 to section 2. Part 2 talks about limitations of suits, appeals or applications going from section 3 to section 11. Part 3 talks about computation of period of limitation from section 12 to section 24. Part 4 talks about acquisition of ownership by possession, section 25 to section 27. Part 5 talks about miscellaneous things from section 28 to section 32, and schedule of the act gives you periods of limitation. Let us look at some of the preliminary points that we need to remember before we start our journey through this limitation act. The first one is you have to remember that bill of exchange includes a hundi and a check. Period of limitation means that the period prescribed for the suit by schedule of this act. Prescribed period means period of limitation computed according to the act. Set off and counter claim are always considered as independent suit. Let us look at some of the important definitions in the act. Section 2A defines applicant, section 2C defines bill of exchange, section 2D defines bond, section 2F defines easement, section 2J defines both things, that is period of limitation and prescribed period. Section 2K talks about promissory note, section 2L defines suit, section 2M defines tort, and section 2N defines trustee. Let us begin with the short notes. The first section is section 3, that is bar of limitations. So this section is applicable on suits, appeals and application, on all these 3 things. Suit, appeals and applications which are instituted after the prescribed period are dismissed, although limitation is not taken as a defense in these cases, and a suit is deemed instituted in an ordinary case when the plaintiff is presented to the proper officer. It is deemed instituted in case of a pauper when application for leave to sue as pauper is made. When there is a claim against a company, the claimant first sends the claim to the official liquidator. Set off is deemed instituted on the same date as suit. Counterclaim is deemed instituted on the date on which the counterclaim is made. Application by motion, by notice of motion in High Court when the application is presented to the proper officer. Section 4 talks about the day when the court is closed. Again, this section is applicable on suits, appeals and application, on all these 3 things. So you have to remember, if your prescribed period is ending in any of these 3 cases, that is suit, appeal and application, it is ending on the day when the court is closed, then you can institute it on the day when the court reopens, and a court will be deemed closed when it is closed for any part of the normal working hours. Section 5 talks about extension of prescribed period. You can extend the prescribed period for sufficient cause. It is applicable on applications and appeals. If you are misled by an order, practice or judgment of the High Court, it is deemed sufficient cause. This section can also be named as doctrine of sufficient cause, condonation of delay. It is not applicable on suits and order 21 applications, and applicable on appeals and applications. Okay, section 6 talks about legal disability. It is applicable on suit and order 21 applications. So what 3 disabilities are talked about in this section? That is, if you are a minor, insane or idiot, then when your disability ceases, then you can institute the same within the same time period. If you were suffering from 2 disabilities, then when both the disabilities have ceased, if the disability continues till the death, then legal representative representatives are given same time after the death as the person had, and legal representatives if are under the same disability, then after the disability ceases. If a person dies after disability ceases, then legal representatives within the same time that is left to them. Section 7 talks about disability of one of several persons. If there is a person who can give discharge without concurrence for other people, then the time will run against all. If that person cannot give discharge without concurrence, then time will not run against any of them, and discharge can be against any liability including immovable property. You have to remember that an HUF manager, that is in Mitakshara law, can give discharge without concurrence, that is the Karta. Section 8 talks about special exceptions. Section 6 and 7 don't apply to suits to enforce preemption, and relief under section 6 and 7 will not be extend beyond 3 years after cessation of disability or death. You have to remember that section 6 is the main provision, section 7 is a supplementary provision, and section 8 restricts section 6 and 7. Section 9 is one of the most important section in the Limitation Act. It talks about continuous running of time. Okay, अब इसके अंदर सिंपल सी बात है, once the time has begun to run, no subsequent disability or inability will stop it, but there are certain exceptions to it. सबसे पहली exception है, if the letters of administration of estate of a creditor is granted to the debtor, तब time रुक जाएगा आपका. Section 12 बात करता है on the day from which the period is reckoned. Okay, तो section 12 भी section 9 को restrict कर देगा, जो कि तीनों चीजों पे लगता है, सूट, अपील और एप्लीकेशन पे. When leave to sue or appeal as proper is made, section 13 के अंदर, which is applicable on suit or appeal. If you are pursuing bona fide proceedings in a court without jurisdiction, then section 14 given in section 14, which is applicable on suit and application, then also the continuous running of time will stop. अगर कोई injunction stay और notice है section 15 के अंदर, then again it stops, which is applicable on suit and order 21 applications. अगर death हो चुकी का case है section 16 के अंदर, then also the limitation, the continuous running of time stops, which is applicable on suit or applications. अगर fraud और mistake है section 17 के अंदर, okay, इसका time period 1 साल का है, आपको याद रखना है. अगर fraud और mistake पता चलने के 1 साल के अंदर आपको इसे pursue करना होगा, which is applicable on suits and applications. Then also the continuous running of time stops. अगर acknowledgement in writing है section 18 के अंदर, which is applicable on suits and applications. Substituting or adding plaintiff or defendant, okay, section 21 के अंदर, which is only applicable on suit. अगर कोई continuous breaches of torts and contracts है section 22 के अंदर, या फिर injury actually जिस दिन होती है, when the injury actually results, under section 23, which is only applicable on suit. तो एक बार section 9 फिर से go through कर लेते हैं. section 9 में सिंपल सी बात रखिए कि एक बार टाइम शुरू हो चुका तो उसके बाद वो नहीं रुकेगा, लेकिन कुछ चीज exceptions के अंदर it will stop, and all these exceptions have been dealt here. अगर section 10 की बात की जाए, section 10 talks about trustees and only applicable on suit. section 11 बात करता है outside the territory to which this act extends. section 19 बात करता है payment on debt or interest on legacy के बारे में. section 20 बात करता है acknowledgement or payment by another person. section 24 talks about the Gregorian calendar or the English calendar. section 25 again very important, it talks about acquisition of easement by prescription. तीन चीजें इस सेक्शन के अंदर इंपॉर्टेंट है कि अगर ईजमेंट आपका पीरियड है 20 इयर्स का, अगर गवर्नमेंट प्रॉपर्टी है तो 30 इयर्स हो जाएगा, और सूट आपको 2 साल के अंदर अंदर फाइल करना है फ्रॉम द डेट ऑफ ऑब्स्ट्रक्शन. सेक्शन 26 बात करता है एक्सक्लूजन इन फेवर ऑफ रिवर्जनर और सर्विएंट टेनेमेंट. ठीक है, तो टाइम ऑफ एंजॉयमेंट ऑफ प्रॉपर्टी, okay, it will be included. section 27 बात करता है extinguishment of right to property, which is applicable on suits. It is an exception to the general rule that limitation only bars remedies and not their right. It is applicable only on suits there and not applications. If a person who has possession or has a right to get possession but he doesn't file a suit within the prescribed period, his right will also cease after 12 years. section 29 के अंदर savings clause दे रखा है, which all sections and acts are saved. Section 25 of the Indian Contract Act, any special law, local law, any marriage or divorce law, section 25, 26, and the definition of easement under Easement Act 1882. Now we will look at some of the most important period of limitations that are given under the act. अगर to set aside summary procedure को आपको set aside करना है, आपको 10 दिन का limitation period दिया गया है. अगर कोई भी केस है, अकाउंट्स, कॉन्ट्रैक्ट से रिलेटेड, डिक्लेरेशन से रिलेटेड, डिक्री से रिलेटेड, इंस्ट्रूमेंट से रिलेटेड, मूवेबल प्रॉपर्टी से रिलेटेड, या फिर किसी चीज के लिए कोई प्रिस्क्राइब पीरियड नहीं गिवन है, तो 3 साल उसके लिए होगा. इमूवेबल प्रॉपर्टी की अगर बात की जाए, हर इमूवेबल प्रॉपर्टी के लिए ब्लैंकेट पीरियड आपको 12 ईयर्स याद रखना है. बट अगर केस है रिडीम एंड रिकवर पोजेशन का तो 30 साल हो जाएगा. अगर आपको सरप्लस कलेक्शंस की रिकवरी करनी है तो 3 साल हो जाएगा. अगर फोरक्लोजर की बात होगी तो 30 साल हो जाएगा. हर मूवेबल प्रॉपर्टी के लिए लिमिटेशन पीरियड 3 साल गिवन है. अगर कुछ टॉर्शियस केसेस की बात की जाए तो फेटल एक्सीडेंट्स एक्ट के लिए आपको 2 इयर्स का टाइम पीरियड दिया गया है. लीगल रिप्रेजेंटेटिव सूट्स एक्ट के लिए भी 2 इयर्स, चेंजिंग यूज ऑफ प्रॉपर्टी के लिए 2 इयर्स, ऑब्स्ट्रक्टिंग या डाइवर्टिंग वाटर कोर्स के लिए 3 इयर्स गिवन है. और ऑल अदर केसेस यानी कि ब्लैंकेट टॉर्ट के लिए आप याद कर लीजिए 1 साल का है. लेकिन अगर कुछ चीजें होंगी जैसे फेटल एक्सीडेंट्स एक्ट के अंदर 2 इयर्स, लीगल रिप्रेजेंटेटिव सूट्स एक्ट के अंदर 2 इयर्स, चेंजिंग यूज ऑफ प्रॉपर्टी के अंदर 2 इयर्स एंड ऑब्स्ट्रक्टिंग और डाइवर्टिंग वाटर कोर्स के लिए 3 इयर्स. अगर ट्रेसपास, कॉपीराइट इंफ्रिंजमेंट, रिस्ट्रेन वेस्ट, रॉन्गफुल इंजंक्शन, रॉन्गफुली डिटेनिंग मूवेबल प्रॉपर्टी, रॉन्गफुली इंजरिंग मूवेबल प्रॉपर्टी की बात की जाए तो 3 साल का पीरियड मिलेगा. ट्रस्ट के केसेस की बात की जाए तो अगर रिकवर मूवेबल प्रॉपर्टी करनी है आपको ट्रस्ट के केसेस में तो 3 साल का पीरियड है. अगर आपको सेट असाइड ट्रांसफर ऑफ मूवेबल प्रॉपर्टी करना है तो 3 साल के अंदर करना पड़ेगा. और बाकी जितने भी केसेस हैं ट्रस्ट के उनके लिए 12 साल का टाइम पीरियड गिवन है. तो हमें सिंपल सी बात याद रखनी है, अगर ट्रस्ट का कुछ भी केस आता है 12 साल का पीरियड होगा. लेकिन इन दो चीजों के अंदर यानी कि रिकवर मूवेबल प्रॉपर्टी इन 3 इयर्स एंड सेट असाइड ट्रांसफर ऑफ मूवेबल प्रॉपर्टी यू विल आल्सो गेट 3 इयर्स. कुछ मिसलेनियस चीजें देख लेते हैं जिनके टाइम पीरियड्स इंपॉर्टेंस होते हैं. अगर कोई भी लेगेसी, हेरिडिटरी ऑफिस, हिंदू मुस्लिम फीमेल पोजीशन का सूट है, सेट असाइड फादर से एलियनेशन का सूट है, एक्सक्लूजन फ्रॉम जॉइंट फैमिली प्रॉपर्टी का सूट है, तो 12 साल का टाइम पीरियड आपको याद रखना है. इफ बाय लोकल अथॉरिटी फॉर पोजेशन ऑफ स्ट्रीट रोड बाय सेंट्रल और स्टेट गवर्नमेंट तो 30 साल का टाइम पीरियड गिवन है. अगर सूट्स एंड एप्लीकेशंस फॉर व्हिच नो प्रिस्क्राइब्ड पीरियड देन यू विल हैव 3 इयर्स. लीव टू अपीयर और डिफेंड सूट इन समरी प्रोसीजर 10 डेज का टाइम आपको गिवन रहेगा.
If you want to purchase this 11-page PDF in which you get both short notes and all state previous year questions at very nominal prices, you can do it from our website or download our app in whichever thing you are comfortable. The links are given in the description box as well as pinned in the comment section.
Now we will take a look at all state previous year questions which have been asked in various examination. Enforcement date है 1 January 1964, 32 sections, 137 articles given है. Objective क्या है Limitation Act का? Vigilantibus non-dormientibus jura subvenient, meaning law aids the vigilant, not those who sleep over their right, and it bars judicial remedy, but the substantive right itself survives and continues to be available in other ways. First attempt on uniform law of limitation was made in Limitation Act 1859. 2A defines applicant, 2C defines bill of exchange, also includes hundi and check. Limitation Act bars the remedies. 2J talks about period of limitation and also the prescribed period. Period of limitation means period of limitation prescribed for any suit, appeal or application by schedule of the Limitation Act. Prescribed period means period of limitation computed according to the provisions of this act. A suit is deemed instituted in case of counterclaim on the date when counterclaim is made in the court. Section 2L talks about suit. Section 3 talks about bar of limitation. Section 3 does not apply to execution proceedings. In Section 3, court is required to consider question of limitation suo motu or even when defendant has not taken an objection of limitation. Suit is instituted in an ordinary case when the plaintiff is presented to the proper officer. Suit is instituted in a case of pauper when application for leave to sue as pauper is made. Suit is instituted in a claim against company being wound up when the claimant first sends claim to the official liquidator. Section 3 is a mandatory provision. In Section 3, suit is instituted after prescribed period of limitation. Then the plea of limitation cannot be ignored and the suit is dismissed. In Section 3, counterclaim is again deemed instituted on the day when counterclaim is made in court. Treated as a separate suit, set off and counterclaim. Counterclaim by defendant in pending suit is governed by limitation. Yes. Limitation Act applies to suits, appeal and applications. If any period of limitation is to be excluded from prescribed period of limitation, the party necessarily has to satisfy section 4 to section 24. Section 4 is related to the maxim lex non cogit ad impossibilia. Law does not compel you to do the impossible. Section 4 is applicable to suit, appeal and application. Prescribed period for any suit, appeal and application expires on a day when the court is closed. Then suit, appeal and application may be instituted, preferred or made on the day when the court reopens. To attract section 4, it is not necessary that the court should be closed for the whole day. It is sufficient that the court is closed during any part of its normal working hours. Plaint is filed next day after period of limitation will not be barred by time if the court was closed for half an hour on the last date of limitation. Section 5 talks about extension of prescribed period in certain cases. Section 5 applies to appeals and application. Section 5 does not apply to suits, execution petitions under Order 21 and divorce petitions in Hindu Marriage Act 1956. Bar of limitation applies to suits, appeals or applications. Section 5 refers to condonation of delay on ground of sufficient cause. Party who pays for condonation of delay under Section 5 has to establish that he was vigilant, he had no negligence on his part and no lack of bona fides on his part. Whether court can grant extension of period of limitation under Section 5 on ground of sufficient cause in case of application under Order 21? Absolutely not. No suit shall be admitted after prescribed period of limitation. Even appeals may be admitted after prescribed period if the appellant shows sufficient cause for not preferring an appeal within prescribed period. Delay in filing suit cannot be condoned under Limitation Act 1963. Section 6 refers in Section 6 a minor includes a child in womb. Section 6 is available to plaintiffs. Disability in Section 6 does not mean disability arising out of insolvency. Section 6 lays down that where a person is entitled to institute suit etc. is at the time from which prescribed period is to be reckoned a minor, insane or idiot, he may institute the suit within the same period after the disability has ceased as would otherwise have been allowed to him from the time specified in schedule. Section 6 does not provide a fresh starting point of limitation. Section 6 does not prevent a running of limitation, only extends the period of limitation. Section 6 applies in case of minor, not a legal disability. Under Section 6, imprisonment, where person is affected by two legal disabilities, where one disability is followed another without leaving gap, then suit and application may be filed after both the disabilities have ceased. If the cause of action for suit arises when plaintiff is a minor, he may institute the suit within the prescribed period by limitation for such suit after he attains majority. A right to sue accrues to X during his minority and X dies before attaining majority and is succeeded by Y, his minor son. Time runs against Y from the date of his attaining majority. Period of limitation for any suit or application shall be deemed to be extended for a maximum period of 3 years from the date of person affected by disability. Section 9. Once the time has begun to run, note subsequent disability, inability to institute suit, make application stops it. Section 9. Running of period of limitation for a suit to recover debt when letters of administration of estate of a creditor have been granted to his debtor would be suspended while process of administration continues. Period of limitation not attracted in case of suit against trustees. Section 10 applies. Trustees trust for a specific purpose. Section 12 subsection 2 talks about in computing period of limitation for an appeal, review, revision, the time requisite for obtaining copy of decree order appealed against shall be excluded. In computing period of limitation for an appeal, the day on which judgment pronounced, the time requisite for obtaining copy of the decree shall be excluded. In computing period of limitation for any suit, appeal or application, the day shall be excluded on which limitation period is to be compounded, judgment pronounced in appeal and time requisite for obtaining copy of judgment. In computing period of limitation for any suit, appeal or application, the day from which such period is to be reckoned shall be excluded. In computing period of limitation for any appeal, the day on which judgment complained of was pronounced and time requisite for obtaining copy of decree shall be excluded. Judgment was passed on 10th July 2022. Decree was prepared on 25/7. Application for certified copy was made on 11/7. Certified copy was ready on 1st August and delivery of certified copy was taken on 5th August. The period will be excluded as per section 12 from 10th July to 1st August. Section 13 applies in case of pauper. Section 14 exclusion of time for proceedings bona fide in a court without jurisdiction. Section 14 where plaintiff has been prosecuting with due diligence and in good faith and other civil proceedings with respect to same matter and issue in a court which from defect of jurisdiction is unable to entertain it. Periods spent by plaintiff is liable to be excluded in computing period of limitation for a suit. Section 14 can be invoked for exclusion of time when the first is withdrawn under Order 23 Rule 1 on ground of technical or formal defect. Plaintiff will not get benefit of Section 14 when another civil proceeding is disposed of after adjudication on merits by a competent court. Jurisdiction to grant exemption in Section 14 is given exclusively to court of first instance. Doesn't amount to due diligence and good faith in Section 14, failure to pay the requisite court fee, found deficient, and error of judgment in valuing the suit. While computing period of limitation of suit, time spent in another similar proceedings in court having no jurisdiction can be excluded if the plaintiff acted in good faith with due diligence in a suit filed by plaintiff. The defendant in his written statement has taken the objection of non-impediment of necessary party. Despite such objection, plaintiff continued the suit and suit was finally decreed. At the first appellate stage, plaintiff withdraws the suit with liberty to file a fresh one on the same cause of action and subsequently file a fresh suit. The period spent by plaintiff in earlier suit under Section 14 is not liable to be excluded as the plaintiff cannot be said to be prosecuting the earlier suit with due diligence in good faith. Under Section 14, defect of jurisdiction must relate to territorial, pecuniary, subject matter jurisdiction. To attract Section 14, which condition is not required to be satisfied, that the earlier proceeding and the later proceeding may be based on different matters in issue. For exclusions of time proceeding bona fide in court without jurisdiction, time during which formal civil proceeding was pending, the day on which that proceeding was instituted, and the day on which it ended shall both be counted. Plaintiff and applicant resisting an appeal shall be deemed to be prosecuting a proceeding. Misjoinder of parties' cause of action shall be deemed to be a cause of like nature with defect of jurisdiction. In computing period of limitation, the period which may be excluded includes time during which any person has been prosecuting with due diligence another prosecution on same fact in good faith in court without jurisdiction, and the period on which prosecution in respect of such offense has been stayed by injunction or order. Period spent prosecuting case under consumer forum can be excluded. Section 15 does not apply to appeals. What is the effect on limitation to institute a suit in cases where statutory notice is required by law to be issued before institution of suit? Prescribed period of notice is excluded. If the defendant is abroad during period of limitation, such period is excluded from period of limitation. Section 16 talks about effect of death before accrual of rights to sue, provided effect of death on or before accrual of right to sue extends to right to sue. Section 16 is not applicable to suits to enforce rights of preemption, suits for possession of immovable property or of a hereditary office. Section 17 refers to fraud or mistake. Section 17 does not take within its ambit appeal. Fraud contemplated by Section 17 is that of defendant. Section 17 does not take within its ambit concealments, frauds and mistakes. Section 18 refers to effect of acknowledgement in writing. It is not necessary that an acknowledgement in Section 18 must contain a promise to pay or should amount to a promise to pay. Acknowledgement after period of limitation is of no effect, not essential requisite for a valid acknowledgement that it needs to be in writing. On acknowledgement, fresh period of limitation starts from the date of signing acknowledgement. Acknowledgement made by a person other than person under liability to pay is good if the person making it is an agent of person under liability. In Section 18(2), oral evidence of date of acknowledgement is permissible if the acknowledgement is undated. Suit can be said to be in limitation even after prescribed period if the defendant acknowledges liability of the plaintiffs right before expiration of the period of limitation. Correct with respect to acknowledgement of liability under Section 18. Acknowledgement can be made to a person other than person entitled to property. Before expiry of period of limitation, A has acknowledged in writing the amount due as debt from B and has promised to pay. What is the effect of such acknowledgement? Fresh period of limitation limitation will start from the date of such acknowledgement. For a fresh period of limitation to begin from the time of acknowledgement of liability under section 18, it is necessary that the acknowledgement must be in writing, made before expiration of prescribed period, and signed by the party against whom right is claimed. In section 19, part payment of debt or interest has to be within the prescribed period for repayment. Section 21 talks about effect of substituting or adding new plaintiff or defendant. After the institution of suit, a new defendant is substituted. The suit is deemed to have been instituted as regards him when he was made a party. In section 21, a suit is deemed to have been instituted in case of new plaintiff impleaded or added on the date on which new plaintiff is impleaded. Section 21 does not apply in case of transportation of parties. Section 22, continuing breaches of contracts and torts. Section 22 is not applicable in case of suit for damages for wrongful detention of goods. Computation of limitation time for date used in instrument shall be calculated according to which calendar? The Gregorian calendar. Section 25, acquisition of easement by prescription. In section 25, the easement rights over the property belonging to government are acquired by continuous and uninterrupted user for 30 years, given under section 25 subclause 3. Suit against the obstruction in the enjoyment of easement rights acquired under section 25 must be filed within how many years of obstruction? 2 years. Acquisition of easement by prescription has been provided under section 25, which provides for use of light or air and for any building without interruption for 20 years. Right to such access or use of light air shall be absolute and indefeasible. Section 25, time limit for acquiring easement by way of prescription. Section 27, on lapse of time, not only the remedy is barred but the right to property is also extinguished. Exception to general rule that law of limitation only bars the remedy but doesn't extinguish the right itself. Section 27, for filing a suit to enforce payment of money secured by mortgage, otherwise charge upon immovable property, the period of limitation prescribed is 12 years when the money sued for becomes due. Section 30, provisions for suit etc. for which prescribed period is shorter than the period prescribed by Limitation Act 1908. Section 29, stipulations for purpose of determining any period of limitation prescribed for any suit, appeal or application by any special or local law. The provisions in section 4 to 24 shall apply insofar as the extent of which they are not expressly excluded by special or local law. Limitation Act applies to civil suit. Limitation Act bars judicial remedy but does not extinguish the right. Expiry of period of limitation renders the debt unenforceable. Limitation Act is a procedural law. Limitation Act is both prospective and retrospective. Limitation for filing suit by mortgage for foreclosure reckoned from the date when money secured by mortgage becomes due, 30 years. Application for setting aside arbitral award has been to be filed within 30 days from the date of service of notice of filing the award. Limitation for filing suit by surety against principal debtor would be 3 years from the date on which the amount was paid by surety to the creditor. Application for bringing on record the legal representatives of the party has to be filed within 90 days of the death. Prescribed limitation period for filing suit for compensation of libel or slander, 1 year. Suit to redeem, recover possession of immovable property, mortgage can be brought by a mortgager within 30 years. Period of limitation for filing suit for compensation of false imprisonment begins to run from time when imprisonment ends. Period of limitation of suit to recover possession of immovable property is comprised in religious charitable endowment transferred for a valuable consideration under Article 96, 12 years. Period of limitation for a suit for possession of immovable property based on title, 12 years from the date when possession of defendant becomes adverse to plaintiff. Suit for which no limitation given in schedule, 3 years. Torts, 1 year. Tort for trespass or compensation, 3 years. Damages for defamation, 1 year. Compensation for malicious prosecution, 1 year. Suits with respect to account, 3 years. Accounts, contracts, declaration, decree, movable property, 3 years. Setting aside an ex parte decree, 30 days. Article 137, 3 years prescribed for filing. Application period of limitation for filing revision in High Court, 90 days from the judgment or order. Recover possession of immovable property conveyed, bequeathed in trust and afterwards transferred by trustee for valuable consideration, 12 years. Period of limitation for prefer appeal against decree or order before High Court, 90 days. Period of limitation for filing application for review of judgment by court other than Supreme Court, 30 days. Application for order to set aside abatement, 60 days. Application to restore suit dismissed for default appearance, 30 days from the date of dismissal. Period of limitation for execution of decree passed in suit for partition commences commences from the date of final decree. Period of limitation for execution of a decree 12 years. Suit for possession of immovable property based on title can be filed within 12 years. In case of suit of property which plaintiff has conveyed while insane, the time from which period of limitation begins to run is when the plaintiff is restored to sanity, when the plaintiff has knowledge of conveyance, where no period of limitation is prescribed, 3 years from the date on which right to apply accrues. In case of suit by person excluded from joint family property to enforce right to share therein, the time from which period of limitation begins to run is when exclusion becomes known to the plaintiff. Period of limitation of suit for recovery of arrears of rent from due date shall be 3 years. Suit for arrears of maintenance 3 years. Limitation for filing appeal commences from date of judgment. A suit to set aside transfer of property made by guardian of wards by the ward who has attained the majority can be filed within 3 years from when the ward attains majority. Period of limitation for filing suit for compensation of injury caused by an injunction wrongfully obtained begins to run from when the injunction ceases. Limitation to obtain declaration of title of immovable property 3 years when right to sue accrues. Article 113 3 years when no period of limitation is given. Minimum period of limitation 10 days. Recovery of possession from tenant begins when tenancy has expired. Enforcement of decree granted by mandatory injunction is 3 years. Recovery of immovable property mortgaged and afterwards transferred by mortgagee for valuable consideration is 1 year. Suit for possession on basis of prior possession may be filed within 20 years. Landlord to recover possession from tenant within 12 years. Foreclosure 30 years. Recovery of arrears of rent 3 years from the date on which arrears become due. Article 112 period of limitation for filing suit by central government 30 years. Period of limitation for suit by principal against his agent for movable property received by latter and not accounted for 3 years from the date when the court demanded and refused. 3 years from the date when agency terminates if no earlier demand was made. So that is it for the video everyone, and we will see you in the next one. अगर आपको ये वीडियो अच्छा लगा तो वीडियो को लाइक करें, चैनल को सब्सक्राइब करें. अगर पसंद नहीं आया तो मत करिएगा. Thank you for watching. I'll see you next time.